Assalamualaikum warahmatullahi wabarakatuh. Let me introduce myself. My name is Dewi Shafitri Wulansari from class AS1. I would like to present my presentation about legal principles. Principles of civil law. 1. Judge are waiting. The judge is waiting for the intention is that the judge is waiting for the right to be brought against him. If there is no claim of right or prosecution, then there is no judge. 2. Judge are passive. The judge, in examining the civil case, is passive in the sense that the scope or extent of the subject matter of the dispute submitted to the judge to be examined is basically demanded by the litigants and not by the judge. 3. Open in court. The examination session in court is basically open to the public, which means that everyone is allowed to attend and listen to the examination in court. 4. Hearing both parties or plaintiff and defendant through letters means that in the law of civil proceedings, the litigants must be equally observed, entitled to equal and fair treatment, and each should be given the opportunity to give his or her opinion. 5. Decision must be accompanied by reasons. A court decision must contain the reason for the decision as the basis for a judge getting. Article 25 of Law Number 4 of 2004, Article 184, Paragraph 1, 319 HIR, 618 RBG. The reason or arguments are intended as a responsibility of the judge rather than his feeling against the community, the parties, the higher courts, and the science of law, so that it has objective value. 6. There is a fee. To litigate is basically charged. Article 2, Paragraph 4 of the Law Number 48 of 2009 and Article 121, Paragraph 4, 182, 183, HIR, and Article 145, Paragraph 4, 192 until 194 RPG. The cost of the case includes the cost of clerkship and the cost of the summons, notification of the parties, and well as the cost of stamp duty. 7. There is no need to represent. HIR does not oblige the parties to represent the case to others, so the investigation takes place directly against the directly interested party. H. Judiciary is conducted with a simple, fast, and low cost. Article 2, Paragraph 4 of Law Number 48, year 2009. Simple, meaning the show is clear, easy to understand, and not convoluted. The fewer and simpler the formalities in the proceedings, the better. Next, principles of criminal law. 1. The principles of legality. These principles relating to a person cannot be subject to a criminal sanction as long as this crime committed is not contained in the criminal code as explained in Article 1, Paragraph 1, which reads, No action whatsoever can be punishable except for the force of the criminal code of law that has been stated. 2. The principles of territoriality. The principles actually applies to international law because it is very important to punish all people in Indonesia who commit crimes committed by such individuals both in Indonesia and outside. 3. National active principles or personality principles. These principles discuss the criminal code against Indonesians who commit crimes outside the country. In international law, this law is called the principles of personality. However, this law depends on bilateral agreements between countries that allow them to prosecute such crimes according to their national origin. 4. Passive national principle or principle of protection. These principles impose the penal code on any Indonesian citizen or foreign national who commits criminal act outside the country of Indonesia as long as it violates the interests of the Indonesian state. 5. The principles of universality. The principles of universality is usually related to the principles of humanity in the sense that the perpetrators of this crime will be subject to a criminal act that applies to the place or where it stops, such as a terrorism crime in which the case has involved all countries or all countries have agreed if such a crime is a criminal act. 6. The principles of no penalty without error or Keenstrafzonderschuld. This principles has the same meaning as the basic meaning of legality itself, so that it is frozen into a fundamental principles that is to becomes the principles of legality. Indonesian constitutional law principles. 1. The principles of rule of law. Based on the description of the concept of the state of law, there are two basic substances, namely 1. The existence of constitutional understanding has the meaning that the government is based on the basic law or constitution, not based on mere power, and 2. Democratic system or people's sovereignty, literally identical with the meaning of people's sovereignty, which means the government of all its people participating in governing or people's government. 2. The principles of power sharing. The 1945 NRI Constitution, as a result of amendments, stipulates for powers and 7 state institutions as follows: A. Examinative power, namely the Audit Board of Finance or BPK. B. Legislative power, namely the People's Constitutive Assembly, which is composed of the House of Representatives and the House of Regional Representatives. C. The power of the state government or executive, namely the President and Vice President. D. Judicial powers, namely the Supreme Court and the Constitutional Court. E. Auxiliary state institution, namely the Judicial Commission. The late Oh my god. Tulis asas negara Indonesia. Oh. The principles of Pancasila. Pancasila is often referred to as the philosophy of the state and ideology country. However, in this case, Pancasila is used as the basis for governing the state's government. In other words, Pancasila is used as the basis for organizing the state. Pancasila as the basis of the state demands that every action of the people and the state of Indonesia must be in accordance with Pancasila that has been established and the basis of the state. So many of my presentation. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Bye.